So welcome everybody. This is Garden Court Mediations webinar, Mediations, When and How to Get Ready for Them. We're delighted to be hosting this event as part of International Mediation Awareness Week. So you may be watching this live or you may be watching it on our YouTube channel. And we're delighted to be part of this event, celebrating and sharing knowledge and awareness about mediation. And it's particularly timely to be hosting this event because tomorrow our Court of Appeal in England and Wales is going to be hearing the case of Churchill and Merthyr Tydfil, which will be potentially discussing the extent to which there should be compulsion to mediate in civil cases in this jurisdiction. So this lunchtime webinar is going to explore questions you may have about when might be the right time to mediate in a case, what cases may present themselves as good opportunities to mediate, how to respond to invitations to mediate, and how to prepare as a mediation advocate. So our first presenter this afternoon is David Watkinson, who is a retired member of Garden Court Chambers. He also was one of our founders and a joint head of Chambers. So we're delighted he's able to bring his expertise to this webinar this afternoon. He practiced as a barrister for 40 years and now is one of our mediation panel. And his advocacy skills lend him expertise in assisting parties to reach resolutions and solutions to disputes that arise between them. And so he has experience of both representing parties at mediation and mediating disputes. His mediation experience goes well beyond his legal expertise as a housing barrister, and he has mediated in a wide variety of disputes. He has an expertise in finding common ground between people who are in dispute and helping them reach agreement. So he's very well placed to talk today to us about what mediation is in civil disputes, providing an overview of why you might want to mediate, what the mediation process is, and in particular, look at the cost consequences of not mediating. So I'm going to turn now to David Watkinson.
Thank you very much, Kate. Okay, so I am starting with why mediate. Imagine for a moment that I am addressing a hall of solicitors, caseworkers, people who are interested in mediating whatever dispute they have. Mediation, it is a procedure for settling disputes, and that is why it is worth doing, because if successful, and most mediations are, you end up with a relieved and satisfied client. It's over, no impending court hearing, no giving evidence, a benefit, not necessarily what you or the client might have got if the case had been fought and won, but enough. And the client can get on with his or her life as can you, the advisor or representative. As an experienced mediator once said, I've never heard of any client coming back and saying, I wish I had never settled that case. But there is another reason, and that is increasingly courts have included in directions that parties should consider mediation or alternative dispute resolution, ADR, and if they decide not to go to mediation, to file reasons why not. And why are the courts doing that? Obviously because of the desire to relieve the pressure on the court lists. And because of that, we see what is contained in the pre-action protocols. As an example, so just slip your eyes quickly through these paragraphs because the slides will all be available to you after this webinar. So this is all urging you to go to ADR on mediation. But the sting is in the tail, paragraph 11. If proceedings are issued, the parties may be required by the court to provide evidence that ADR has been considered. A party's silence in response to an invitation to participate or a refusal to participate ADR might be considered unreasonable by the court and could lead to the court ordering that party to pay additional court costs. And I'll be coming back to that. What is mediation? Is a helpful indication from the pre-action protocol for judicial review. If we go right to the very bottom there, we have in short form mediation, a form of facilitated negotiation assisted by an independent neutral party. And this leads us to the third slide. I'm going to do this at a gallop, as other speakers are going to give more detail. First point about mediation is it's voluntary. And I'll be coming back to that. It's voluntary at present. Parties have to agree to mediate. So the process starts with one party approaching the other, or a mediator or mediation provider making the approach. Second point, the mediator is not a judge or an arbitrator. A mediator makes no rulings. She or he hears no evidence, makes no findings of fact, expresses no view as to the outcome of the claim, who is right or who is wrong, does not advise. That is what the lawyers are for. By now you're wondering what a mediator actually does. Well, a mediator is a facilitator, at least in the system that prevails in the United Kingdom. She assists the parties that have come to a settlement. And she or he enables the parties to peer into the abyss and to consider the strength and weaknesses of their respective cases, the effects of loss, and the benefits of settlement. Mediation also enables the parties to be involved, because they have the opportunity to speak, to express a view, and hear from the other side at the mediation. Third point, the mediation is confidential. That means that what is said or done in the mediation stays in the mediation. It cannot be relied upon in the legal proceedings, if there are any, unless the parties agree otherwise. And what is said between the parties and the mediator in private session is confidential between them. Again, unless agreed otherwise. Procedure. Now, this is where I'm really starting to gallop, because others will come back to that. But here are the stages: agreement to mediate, agree the mediator, agree the mediator's fee and shared payment, agree the date and location, enter into a mediation agreement, prepare the mediation bundle, prepare the position statement, attend with authority to settle. That is very important. And finally, with luck, the draft settlement agreement. I'm turning now to the consequences of refusing to mediate when that proposal is made. It is an irony, perhaps, that urging a procedure designed to avoid litigation has led to a cluster of cases on when parties are justified in refusing mediation and the consequences of doing so. I've picked out a selection of 5 cases out of the number which have arisen. And just so you have them all, because that gives you the sweep of the cases that I am going to talk to you about. And I've picked out some key quotes. Now, I'm not going to read them out because, again, you'll get the slides after this webinar. But as you can see, a sizable body of case law has grown up. And of course, they go both ways, as cases tend to do. But the consequences of getting it wrong, it can be serious. If a party refuses to engage in mediation and the court later decides that was unreasonable, then a successful party can be deprived of costs which they otherwise would have been entitled to, possibly removing the benefit of success. What makes it even trickier is that that issue is not decided until the conclusion of the case by the trial judge, and is a decision which itself can be the subject of an appeal. However, from the cases that I've put up and the others, certain principles and trends can be derived. First of all, and this is, if we just go back, first of all, PGF2, a simple refusal of a proposal for mediation by itself is unreasonable. The strength of a party's claim or a party's defense, the weakness of the other party's case, are none of them legally justifiable reasons for refusing mediation. Whether to propose mediation or refuse it is a judgment call. Refusal should be supported by reasons which can withstand the scrutiny of the court. Cost sanctions may not follow an unreasonable refusal if other factors make such an order unjust. If we could, those include if the party that refused mediation was willing, however, to negotiate settlement. If that party was pursuing other means of settlement, for example, Part 36 offers or early neutral valuation, or continuing to consider mediation during the process of the proceedings. If the proposal for mediation was too close to trial, then that too would be a reason for refusing mediation or succeeding in a significant part of the case. These aspects are particularly covered in the Richards case, which is the last case on the page. So these cases emphasize that ADR options must be taken seriously by the parties at all stages. So at all stages, the means to settle the claim should be considered and reasoned decisions made if there is refusal to mediate or engage in ADR, which can be placed before the court. Because if you just have a look at the DSN case, you can see there the directions that the master made. At all stages, the parties must consider settling this litigation by any means of ADR, including mediation. Any party not engaging in any such means proposed by another must serve a witness statement giving reasons within 21 days of that proposal. Such witnesses not to be shown to the trial of judge until the questions of costs. And that form of order is now not uncommon. If we are going now at mandatory mediation, where are we? So taking this as quickly as possible, are litigants going to be required to mediate their cases before the hearing? In Halsey, first case on the page, the Court of Appeal rejected the concept of compulsory mediation. As I stated before, it is a basic principle of mediation that it is a voluntary procedure. The court held that to require parties to mediate would deny the right to access to the courts. And further, the court considered that to require mediation would be a breach of Article 6 of the European Convention of Human Rights, the right to a fair trial. That was in 2004. Then in 2021, the Civil Justice Council published a report on compulsory ADR. This was written by a distinguished panel headed by Mrs. Justice Asplin. This report differed in its opinion from Halsey. It considered that parties could lawfully be required to participate in ADR. It pointed out that doing so did not require the parties to settle, but to mediate. It set out a number of criteria identifying cases suitable for such referral. For example, confidence in the ADR provider, whether parties needed and had access to legal advice, and the stage the proceedings had reached. However, the Civil Justice Council is not a court, so Halsey remains the law until further case law decides otherwise. But even if the principle was established, a number of areas were left uncovered in the CJC report. First of all, finalizing or agreeing the criteria for referral, identifying the areas of law or types of cases for which referral is appropriate. What would be the sanctions for non-compliance? ensuring a sufficient source of mediators and their regulation. However, before any of this has been sorted out, the government has gone ahead and after consultation has produced a report increasing the use of mediation in the civil justice system in July of this year. This proposes requiring mediation for initially all claims valued at under £10,000, i.e. small claims as decided by the government small claims system. This system of compulsory mediation, however, has yet to be set up, and much the same loose ends apply as were left after the CJC report, apart from the nature of the cases that are being referred. Nor is what is proposed mediation as usually understood and described earlier. Instead, what is envisaged is a 1-hour session during which the mediator talks separately to the claimant and defendant about the issues and how to settle. This form of mediation does have a precedent, and that's to be found referred to in the Rental Mediation Service Pilot Post-Implementation Review in February of this year. This pilot provided a system of referral of mostly private sector possession claims to a duty advisor who would decide whether to refer the case to mediation or not. It ran from February 21 to October 21. It was to meet an anticipated tsunami, it was said, of housing possession claims once restrictions introduced by the COVID crisis were lifted. 10,000 referrals to mediation and 3,000 success rate of those mediations was estimated. In the event, there were 22 referrals to mediation. 9 mediations took place, 4 succeeded, although one of those did not result in a court order. So the result was 3 successful mediations from an 8-month pilot. The review looked at what went wrong. I'm going to skip over what went wrong in view of the time, but to observe that the mediation consisted of a 1-hour session with one of a panel of mediators, and I'll just add this, the review found, who had limited understanding of housing law. So this brings us back to the last case on the page, and this is the case of Churchill and Merthyr Tydfil County Borough Council, due for hearing in the Court of Appeal tomorrow. This, it is expected, will reconsider Halsey, though it does not directly relate to mediation. Briefly, the claim concerns an allegation that the County Borough Council allowed Japanese knotweed to enter the claimant's land. The council maintains the claimant should have used its dispute resolution or complaint service before issuing the claim. 3 mediator bodies, including the Civil Mediation Council, have intervened. Watch this space for the outcome of this case and stay tuned. Thank you very much.
Thank you so much, David, for a whistle-stop tour, providing us with an overview of mediation and also the case law in relation to guidance on cost implications of mediating or not mediating, or not sending out an invitation to mediate or accepting one. And we're going to turn to those knotty issues with Helen Curtis in a moment. Helen is a very experienced mediator. She's an accredited civil mediator. She also has a background having previously volunteered as a community mediator, and she has also been trained to facilitate restorative conferences. So it's not surprising that she is described as a mediator with excellent interpersonal skills and ability to keep a focus on coming to an agreement and mediate in disputes where there is a high degree of strong emotion, sensitivity, or that parties appear to have been entrenched, and her constructive approach has enabled her to bring long-standing disputes to a resolution, having come to mediation. And her expertise is reflected in the fact that she is co-author of Making Mediation Work for You, published by Legal Action Group in 2012. So we're going to turn now to Helen Curtis, who's going to talk about when and how to get ready for mediation. Thank you, Helen.
Thank you very much, Kate, for that very kind introduction. And it's far too modest of you to not name yourself as the key author of the LAG publication, Making Mediation Work for You. Thank you very much, David, for that really kicking us off with that comprehensive overview. I'm going to touch on the invitation process, how to initiate an invitation to mediate, what to do if you receive one, how to respond, and how to get ready for mediation. I'll speak for about 15 minutes. I have my timer on, and I can be muted if I'm going over time. So before I go into some of the detail, I just want to look at some of the contexts in which mediation can occur. For example, in the employment sphere, there can be an offer to mediate before a tribunal claim is even before the tribunal. Once it is before the tribunal, mediation can be offered for free as part of a judicial mediation, and that's carried out by an employment judge. I think there is a question in the Q&A. There aren't cost consequences for a refusal to participate in a judicial mediation. And as David has mentioned, confidentiality surrounds the mediation process. And so if in the unlikely event of a judicial mediation not resolving the matter, then the tribunal continues in front of an entirely separate judge who has no recourse or access to what took place in the judicial mediation. In the education sphere, and Kate is an expert in this, and with our colleague Margaret Doyle, who's also written about mediation in the SEND context, and both appeared, in fact, on our webinar that is on our YouTube channel that Kate's mentioned already, and that was in May of 2021, I think, along with Gronya Mellon as well, looking at in more detail the mediation process where there is a dispute about a young person's education, health and care plan and the obligations that surround that process. So if you want to look at that in more detail, then there is a webinar that deals with that. As David has mentioned, the civil procedure rules are in play with civil disputes. There are case management powers for judges to encourage parties to pause and step aside and away from the courtroom. The general period of time is approximately 3 months. Sometimes parties ask for that stay to be extended because there's difficulty with diarising a convenient date, or there is a grumble about an aspect of the mediation bundle, or there is some other potentially satellite dispute that threatens to derail everybody's desire to get the mediation process underway. So case management powers allow for the parties to have time to consider ways in which they can explore resolving their dispute. At the moment, there is, David's already mentioned the steps that the government are taking and have taken in relation to making mediation part of the legal landscape. The online civil money claims process is a rather blunt invitation because you're automatically deemed as accepting mediation unless you opt out of it. And that's a pilot that's running until the end of this month. So, looking at invitations to mediate, how do we feel when we receive an invitation? If I'm going to my niece's 21st, I'm delighted, I'm excited, I want to go and see everyone else who's there, and I'm going to be looking forward to that. If I'm receiving an invitation to I'm not going to name names, but a rather more perhaps onerous duty, a duty to attend something that really I should go because somebody else wants me to go, but it isn't really my bag, then I'm not going to be looking forward to it too much. Am I going to get the most out of that day or that evening because of the way I feel about it? Who knows? All of these things, although personal to me now, are very much present in the parties when they're in a dispute. And if somebody who they are in dispute with says, come to mediate with me, the response isn't automatically, yes, please. And when we issue an invitation, or when an invitation to mediate is issued, there has to be some thought about when to issue it in order to get the best response, how that invitation is worded, and how also the client who's initiating that invitation is going to be protected, in a sense, from a rebuff. So sometimes invitations will be couched in terms which say this is going to be reviewed, we're not prepared to mediate, or we want to mediate now, but if you're not prepared to, then we would welcome you reconsidering this at a later stage in the proceedings, if proceedings have begun. So there's lots of grey areas around the time at which to mediate. Some people say sooner rather than later, but certainly a discussion about whether to mediate must take place, I would say, as soon really as there is a dispute, because people's feelings change as the dispute and the litigation process progresses, and there may well be benefit in revisiting a decision whether to initiate the offer or an invitation to mediate at a later stage. So formally, a formal invitation to mediate, which ties in with some of the cases that David was talking about the consequences for refusal, has to be properly, in my view, properly set out with reasons as to why it would be useful at this stage, potentially given the imminence of a court date or where the case, where you are in terms of the court timetable, that there is sufficient evidence now for the parties to reflect on what their respective strengths and weaknesses are of their case. They understand the merits of the other party's case, but they want to make a cost-saving decision to effectively pause the accumulation of legal costs and reach a resolution. Crucially, they need access, the parties that is, to independent legal advice so that they fully understand what an offer which could resolve matters might look like. And that keeps people's expectations in, well, I would say a more realistic ballpark, rather than a party who is a litigant in person without access to independent legal advice, and their sense of grievance correlates to the outcome that they need to satisfy them, that they can solve or resolve the dispute. And sometimes that can be unrealistic. So access to independent legal advice is very important. And then who is going to make this invitation to mediate? Is it going to be where pre-action correspondence between lawyers has been fairly civil and amicable, and so there can be a natural semi-negotiating invitation which flows from correspondence which hasn't become with an edge of hostility or any unpleasantness, as sometimes pre-action correspondence can contain that. In that case, is it better that the invitation comes from the mediation provider? In our case, Helen Shields, who's our mediation administrator, has a task which is quite unique in the sense that she is corralling different parties, the diaries of different client bases, to see whether or not there is a date that they can all do. And we have found that sometimes people's resistance to the mediation process can manifest itself in a reluctance to agree a date. So who sends the invitation can be as important as what the invitation actually says. David has touched on the consequences in terms of responding, or rather failure to respond, which I endorse. So the essential message on how to respond to an invitation is make sure you do respond, whether it's positive or negative or equivocal. A response is crucial, and it can always be caveated with an expression of or willingness, I should say, to review a decision if it's negative at one stage of the proceedings, to review it at a later stage. It also offers the advisor an opportunity to really drill down into what is important for their client. So the client, of course, may want to resolve matters and put an end to this dispute, but what does that client need from the other party or parties in order to resolve matters? Because sometimes, and in my experience quite often, it's not just about the money. Of course, it is about the money on many occasions, but there are ancillary matters, and it's important to know in advance how the client in dispute, where they put their priorities, what is it that they really need. Sometimes an apology carries far more than the advisor anticipates, and it's important to understand what is driving the client's need in terms of what resolution could look like for your client. So that ties into my next bullet point about where does the value of settlement lie for your client? What is it about getting rid of this dispute that really matters to the client? Is there, as in one of the mediations that I've done, the prospect of a fresh business relationship, a new venture, which may go some way to not necessarily repairing what's happened in the past, but presenting a clean slate and providing both sides an opportunity for some commercial advantage without doing so under the shadow of a dispute which is potentially destructive. So it's about understanding what goes into the mix, and all of that has to happen before any date of when the mediation is actually going to take place. So David has said that been through some of these topics already, but the practicalities are to agree on a mediator, whether it's via recommendation or through a provider, to agree a date, whether it's going to be like this on Zoom with breakout rooms on Zoom, or whether it's going to be in person. And if it's going to be in person, where's the venue going to be? Do you have half a day to give to this? Does it need a whole day? Do you need 2 days over a course of a week? What is it that people are prepared to commit in terms of time? And how will the fee be split? Usually it's split equally. If there are genuinely more than 2 parties, because sometimes there might be 5 parties, but really 3 of them have the same interests. So discussions about how the fee is to be split is important. It's not preparation for trial. So lever arch files, tabbed indexes, bundles of legal authorities, that's not a mediation. That's not mediation preparation. A position statement does need to be drafted, and that can contain any offers that have been made, any reasons why offers haven't been made, or the ones that have been made have been refused. Costs are a key issue, because costs will have already been generated and there needs to be some thought as to what costs are going to be incurred if the matter proceeds to trial, and what is the value of bringing that liability, cost liability, to a swift conclusion. I'm just looking at the time, thinking I may need to come to a swift conclusion as well. But the key aspect is to remember that that mediation process is going to be conducted in confidence. There is confidentiality that people sign up to in the agreement to mediate, and that binds them. So what's said and discussed in a mediation can't be deployed if the matter goes to trial. And that provides a freedom for the parties to really explore different ways without prejudice, without being attached to any particular option that's discussed before matters finally do reach a settlement agreement at the end that people can sign and is enforceable. That's the key. It's an enforceable decision then, bringing the litigation to an end, but providing for the resolution to be legally enforced if anyone departs from it. And those occasions are very rare, because people who have made the decision themselves rather than had a decision imposed on them are much more likely to comply with the terms of it. I'm going to skip through these because I can see the time. If I have got, yes, I am right about the time, sorry. This is the case that's relevant to reassure you that confidentiality is a real thing in mediation. These slides just touch on costs where there is a legal aid certificate and one of the parties is legally aided, and how they can recover their costs, and what the cost is for the mediator. The mediator's fee under legal aid is set by the legal aid agency, and the prospect of the legal aid agency getting up to speed for civil mediation, we're not quite sure when that's going to happen. They're very good on family mediation because that's more well established within the legal aid sphere, but civil mediation less so. But it's still there, and the mediator will be paid where there is a legal aid certificate in place. So I'm sorry to rush the last few moments, but I think I need to, because otherwise you will be deprived of all the lovely images that I understand Abby is going to be able to use for her presentation. Thank you very much.
Thank you so much, Helen. And maybe we can touch upon some of those quite tricky and thorny issues in relation to funding, particularly where you're publicly funded, where perhaps mediation hasn't been sufficiently utilised as an alternative dispute resolution for parties. But thank you so much for that fantastic presentation. And we're now going to turn to Abigail Holt, who is both a barrister and mediator here at Garden Court Chambers. She has 25 years of experience working as a barrister in accident, disease, health and medical related issues, and has been a fully trained mediator since 2011. She brings not only expertise as a trained mediator, but also as a mediation advocate. And she's now about to talk to us about mediation advocacy. Her most recent mediation work has been in relation to complex personal injury cases, which were not amenable to settlement by joint settlement meetings or commercial, but also in commercial lease disputes. Mediations really can be an opportunity, as she has experience, to reach resolutions that are beyond the scope of legal resolution that can be offered by courts. I'm going to turn now to Abigail Holt to talk about mediation advocacy.
Thank you, Kate, for your kind remarks. Okay, so I'm going to talk about what's on the tin, effectively, advocating for mediation and being the mediation advocate. Now, you're just going to have to bear with me for a few minutes just while I find the tin opener and explain that Jeanette Winterson has been a bit of somebody that's inspired me in relation to this talk. You may be aware of her famous film and book, Oranges Are Not the Only Fruit, which talked about her unusual childhood as an adopted child being brought up by an evangelical Christian family in the in deepest, darkest Lancashire, where her mother in particular was a very strong personality, and she was brought up with this very extreme version of Christianity. The second part of her autobiography really is in this book, which is less famous, with the fantastic title, Why Be Happy When You Could Be Normal? And that brought me in mind of mediation, because the attitude sometimes with legal advisors, those involved in litigation, is why mediate when you could litigate? But I think that the answer to that conundrum really is given in this wonderful quote from Strasser and Randolph: to remain in conflict with another defies rational scrutiny. To continue in a commercial dispute resists economic analysis. So I'm just going to very briefly talk about some of the nuts and bolts of being a mediation advocate. Okay, and here to cheer you up on probably a gloomy November evening, lunchtime, I should say. It's certainly the picture here of two friends that I came across on Christmas Day last year in Spain, where I have a connection. And this is two reluctant, resistant asses who didn't want to talk to me and my family, despite that we were offering them handfuls of grass from beyond the fence where they were stuck. And really using these stubborn, disinterested, unfriendly asses to think about some of the reasons why people might not want to mediate, whether it's legal advisors or indeed the parties themselves. Well, people can be reluctant to mediate for a variety of reasons. It may be unfamiliarity with the process. And in my experience, sometimes you have to spend quite a bit of time explaining to, in particular, a litigant who's never been in litigation before, all the complexities of the civil litigation process. And then you have to compare and contrast it with mediation. So that can take time. And it's, you know, if you're going to be suggesting mediation, you really need to give people time to understand the explanations, ask questions, think about it, and again, forward planning in terms of introducing the idea of mediation to perhaps to other legal advisors or to the client is really important. I also think a reluctance comes from a fear of losing control. That may be the legal team, the legal advisors who are afraid of losing control, but also the litigants themselves. And I'll touch on this again in a minute. There's also a very understandable fear of giving too much away and revealing weaknesses in the case. So as the mediation advocate, you have to make sure that you're protecting your client and your those who are also the advising the legal team, to make sure that that there's a proper balance between what may be revealed to the other side and what is kept back, because of course the reality is that occasionally people, the other side, don't come to mediations in good faith, and they may be trying to use it as an opportunity to obtain information. So some care needs to be taken about what you're going to say and what you're absolutely not going to talk about. Another stumbling block in terms of mediation can be the whole thorny issue of cost building, which occurs in some types of litigation. And it's very difficult unless both sides want to or are willing to compromise and willing to come to mediation, the whole issue of cost building can be a problem. And I think it's important to talk about that in a direct manner. If one side is bolstering their case with very detailed investigations, then it's very difficult for the other side not to do the same thing and to protect their interests. And at the end of the day, you can't make someone see sense and you can't make someone settle, which is very difficult in terms of civil litigation where you're representing claimants. again, confronting a difficult issue. Some people, I can think of a colleague who's had 1 or 2 bad experiences with mediation. If you have had a bad experience with a mediation, I think the thing to do as an advisor is to think what went wrong, why, and what, as with all else in life, what you can learn from it. What is it about the process that puts you off as an advisor, or what might put the client off, and to help them and counsel them through their reluctance. And it's important, if you can, to discuss the pros and cons, the fears, the potential pitfalls, honestly, in advance, in private. And at the bottom, at the end of the day, the bottom line is that the process will only work if the litigators and the clients are able to invest emotionally in the process and to trust the process. In terms of another significant issue that has the tendency sometimes to prevent people to be open to the idea of mediation is a lack of realism, and inspiration here from Gabriela Garcia Marquez, who wrote, as you know, in the style of magical realism. I think often parties do indulge in magical realism. They put a faith in the court system that maybe is misplaced. That if somebody has not litigated before, they've never been through the court system, they're not aware of how emotionally brutal the adversarial process can be, how the less than confident, which of course is many people, if not more people, if not most people, when it actually comes to going to court and walking through the door, become absolutely terrified with the possibility of that undermining the quality of the evidence that they can give. Also, people, I think clients want to go to court, if they do want to go to court, because they have this overwhelming need to feel listened to and acknowledged. But sadly, the court system doesn't give them that often. You know, my experience in civil litigation, the trial judge will be, they'll be introduced to the witness or to the claimant. Their witness statement will be shown to the court. The person will be asked to confirm the dates and their signature, and then they're straight into cross-examination. There's no opportunity for them to feel that they've told their story, even though it's set out in the witness statement and the judge will have read it. So they're not going to often come away feeling listened to and acknowledged. They'll feel brutalized by a clever, effective cross-examination. Of course, there's also the lottery of which judge you get. And the sort of psychologically standing behind this is what Paul Randolph describes in this quote: each party fervently believes their position to be the only objective and universal truth. They are driven in the belief that they are being true to themselves, and that a judge, arbitrator, mediator, or other conflict resolver will eventually agree with their objective truth. Sadly, I don't think that is what people experience. So if we were live now, I'd have a little quiz and see if people could identify in International Mediation Week which courts these are. Obviously, the middle one is easy. There's one here in Prague. We have the court in Teruel in Spain. We have the Supreme Court in Lisbon, and also the Supreme Court in the UK. But I think that litigants believe that judges are on a mission to diligently search for the truth, and the anxious scrutiny of the evidence will reveal the particular litigant was right all along about everything and will be vindicated. But of course, litigants don't understand the blunt tools of burden of proof or the crudeness of weighing devices of balance of probabilities. And I think litigants, it's very difficult to explain in advance and describe how, once they walk into the courtroom, to a large extent, they're essentially handing over the case to the judge, regardless of how much time the judge has had or not to read the papers and prepare the case, the foibles of the particular judge. And at the end of the day, the judge has the ultimate discretion to decide the evidence and to put the emphasis on the evidence that they feel to be the most important within the legal framework. So choosing the mediator, this can be, in my experience, a bit of an issue. A good mediator, it's fair to say, can mediate anything, but certainly in the area of work that I practice in, issues that the legal advisors and also the litigants worry about is the specialist knowledge of the mediator. In the areas that I mediate, people tend to actually effectively demand that somebody has the specialist knowledge, and that then immediately brings into bear the mediator's professional background. And there is an obsession in personal injury and clinical negligence work in particular about whether the mediator has a defendant insurance background or a claimant background. And it can be difficult, but it's really important to research somebody who is genuinely able to be impartial and to communicate that neutrality and impartiality. You need to be confident that somebody can see both sides of the dispute. And I'm also aware that we're running out of time. Helen has touched on position statements already. Super important. I think of the position statement for me when I'm acting as the mediation advocate is it's the way that I do the preparation. It's often a good idea to do 2 position statements. Well, obviously you do one, you do the longer one first, and then you delete out for the shorter mediation position statement. The position statement being the longer one, which talks about the weaknesses and possible remedies and the issues that you might not want the other side to see for the mediator themselves, including also things like complex calculations, whereas the position statement for the other side will be slightly different. But I think one trap that some mediation advocates fall into is to turn the position statement into a skeleton argument, and obviously it's not. It's a different it's a different tool. In terms of preparation, Helen's already touched on this. You need to be, and I think David, need to be confident that there is authority to settle. Is there an insurance reserve that's going to cover the potential settlement? If a potential remedy might include transfer of property, do all the owners know? How quick can that be done? Are there any charges over the property? And as mentioned before, the whole thorny issue of costs, it's super important in my view to have a detailed cost budget or statements of costs so that you can roll up the costs as well as the actual dispute and be really ready to do that. Overall, I think the role of the advocate is to nudge the parties to have to take on a different perception of the dispute, and also to give them a vision of how the dispute can be resolved. And as mediation advocate, that involves actually different skills. It involves having soft, as it were, psychological skills, and you have to tread quite a difficult line between communicating to the parties and to their legal representatives that they are they're not abandoning their case altogether, and that they can continue with litigation, not having revealed too much should that be required, whilst at the same time trying to support the mediator in finding that sweet spot of compromise. And also that involves creating the circumstances whereby the other side, if there is a losing side, the side that might have to make the greatest compromise, them going away from the mediation feeling that they are not being punished or not being humiliated, because if they feel those things, then they are unlikely to compromise in any event. Helen's already touched on the remedies available at mediation. There is huge
Sorry, I hate to do this, but I am going to have to encourage you to consolidate your final few points so we can also just have a chance to touch upon some questions.
Yes, we've already, yeah, thanks, Kate. This slide was simply to emphasise that other remedies are available in mediation that are not available in litigation, and there is a real time and a place for mediation. I would emphasise what was said by Helen about confidentiality and the fact that during a mediation people need to feel safe. Very last anecdote, I was involved in a mediation years ago which was set up in a hotel where people had parties had different rooms, but there's a very narrow corridor. We had to make sure that the parties who were very much at loggerheads at the beginning had separate access to loos so they didn't keep bumping into each other. So practical issues need to be taken into account. Thank you very much.
That was incredibly informative. Thank you so much, Abby, for whistling through some really challenging and tricky issues that have to be considered when advocating in a mediation and also selecting a mediator. I'm just looking at the questions in the Q&A. There's a question in relation to it. The question is this the same in an employment tribunal? I imagine this is referring to costs. So the cost sanctions that apply, and we were talking around cost sanctions that might apply when not accepting an offer to mediate or not considering ADR, do they apply in the employment tribunal?
And I basically no, because if it's a judicial mediation, because the question is employment tribunal, so I'm suggesting that the question is referring to a judicial mediation which is offered for free and there's no obligation to accept because it's voluntary. So there aren't the cost consequences of not having a judicial mediation in the employment tribunal. Just in relation to the Q&A, Kate, I have, just because I thought we were running out of time, I've answered one of the questions about the consequences for a statutory regulator, and I've written the answer to that particular question. I know there are other questions, so I'll hand over to you how you wish to deal with it.
Yes, so Helen has addressed a question which is around the risk or consequences that may apply in statutory for a statutory regulator in refusing to mediate, and it really I think is dependent upon whether that question really goes to if mediation has been offered in a regulatory context, would it be reasonable to refuse it? And that would be part of what was the framework and the guidance around statutory, around the processes in that statutory regulation, in regulatory processes. There is a really pertinent question in relation to and Helen, this is where your slides, we were hurried over the end of them, talking about what happens where parties or a party is legally aided, and there is a resolution that is proposed to be a drop hands position. In other words, each party bears its own costs. Can you touch upon how this might be addressed, because there may be a risk of not reaching a settlement, but there is an undue, an adverse situation placed on parties who are legally publicly funded.
Oh yes, thanks, Kate. Abby touched on this a few moments ago. It's almost as though you've worked all really hard all day and you've got your substantive dispute solved and everyone's about to heave a sigh of relief, and then someone says, actually, we were working on the basis that obviously you'd be paying our costs. And then all of a sudden you're into a different mediation because the costs issue really threatens to completely sabotage the agreement. So what Abby was saying about having your cost budgets or your the information about costs, I try and get the parties to share that in advance of the mediation so that it's out on the table, it's up front beforehand, and really to almost say if you're advising under public funding certificate to say at the outset that you're aware of all the cost situations. However, because of the funding arrangement, and other people have different funding arrangements, they need to be upfront in terms of people's discussions to avoid feeling that you're on the back foot towards the end of the mediation and you're going to have to accept some form of cost concession. The costs need to be almost fought over as much as the substantive dispute, because it will impact on the client. The legal aid agency will pay for the attendance of a legal advisor, not necessarily counsel as well as solicitor, but a legal advisor at a mediation. So there are some costs that the legal aid agency will cover, but I think you have to go through it quite carefully beforehand, and it is all in the preparation on the costs issue, in my view, so that you can be resilient to the other side saying, well, let's all bear our own costs. And then if sometimes it works out that if you're saying, well, that's just, there's no traction there at all, so if you really want a settlement, you're going to have to come back to us with something different on the costs, because you can't do all of that work and then effectively feel like, or the client ends up feeling that they've lost, because that any money that's coming is going to disappear on the costs issue. I'm sorry, that's not a very clear answer. It's not very reassuring.
No, I think it touches upon, Helen, thank you very much. I think it touches upon how complex the issue of costs. Often it does threaten to undermine or derail the whole mediation process. I think it's really helpful to clarify that having it front and centre and of the agenda, as it were, for the mediation is very helpful. And I think it might lend itself to a whole topic in itself for a future webinar. Just to pick up on a couple of final questions in the chat. Can cantankerous parties really accept the spirit of mediation? It's a good question, because it's absolutely right that you have to enter the mediation process with an openness and a willingness to settle. And if you are advising a party and you don't think that they are able to enter with that process, that might affect how you respond to either a decision to propose mediation or to accept it. And is the content confidential, or is the outcome also? It's open to the parties and the mediator to reach a settlement that is an open agreement. It may well be that it has to practically be shared with other people in order for that mediation agreement to be implemented. So it's open for the mediation agreement to not be confidential, but the...
Should we just add to that, Kate? Sorry to interrupt, just to emphasise that the content of the mediation is definitely confidential, but sometimes parties will craft some sort of public statement or a press release that they can then couch the terms of what was resolved, and keeping what they need to keep private, but allowing a public body or whoever it is the necessary information to know that a mediation has taken place, it's settled. The terms of the settlement may or may not ever be public, but the parties are encouraged by the mediator to prepare a statement that they can jointly sign, which can cover that eventuality, but that will not dent the confidentiality that is attached to the mediation process itself. Sorry for cutting across there.
No, that's really helpful. Thank you, Helen. And with that, I hope we've answered or touched upon the questions that have been raised. Thank you all for attending. It's been an incredibly thought-provoking webinar covering a vast breadth of material, all aspects of mediation. I hope you come away better educated. Helen's going to tell me something I forgot.
No, not at all. Sorry, Kate. Just to say there's 3 more other questions. And so I appreciate, on the one hand, we've gone over time, but on the other hand, there are still over 60 people here. So I just wondered whether we take a few moments.
Going, and hopefully YouTube can edit away.
Yes.
So thank you very much. Sorry, I didn't scroll down. User error. So to touch upon the final questions, how do you invite someone to mediate? Do you need to use a specific type of letter?
Maybe that others on the panel have a view about this. My view is that there isn't a template, but people might devise their own. And a general letter is fine, provided that it's clear and it communicates what you want it to say. So I think that that's the answer. There's no specific prescribed letter, there's no form, for example, but it's a general letter will suffice, unless David and Abby want to.
I was just going to add that it makes sense that ultimately, just with a view into the future, if the mediation doesn't work out, it needs to be a letter that potentially you could show to the court. So it doesn't contain any private confidential information that the court can't see if there's a cost dispute later down the line. And whilst I'm speaking, I'm just going to jump in, if it's okay, Kate, to deal with somebody's asked a question, what other processes are available for litigants seeking judicial evidence-based outcomes other than court? Is arbitration suitable for this purpose? Well, yes, it depends what type of case you're dealing with. But also early neutral evaluation is a really sensible way forwards as well, that can work really well, where the person that's asked to effectively sit in the chair of the judge, as it were, and write an opinion, which is a little bit in the style of a judgment, whereby they make a decision and they have to point to the evidence to give the reasons to explain that decision. So arbitration and neutral early evaluation. Thank you, Kate.
And would you think that under the Ministry of Justice proposal about mandatory mediation in small claims settlements, the question is, will the small claims mandatory mediation process be undertaken by trained and accredited mediators? My understanding, it's being undertaken by in-house mediators. But David, I feel you're going to answer that question for me.
Yes, sure. Well, we haven't the faintest idea, I think, is the answer to that question, because all practical steps in setting this system up is being considered, but we don't know, we have no results. And the track record is not good, because, as I said, in relation to the possession claims pilot, the mediators were not trained in the area with which they were dealing. And it's pretty obvious from the fact that we are talking 1-hour telephone mediations here, that the Ministry of Justice is not proposing spending a great deal on it. So I think we wait to see what comes out of this with trepidation.
And on that note, thank you to our panelists, Abigail Holt, Helen Curtis and David Watkinson. It has been a pleasure, and I will bring this webinar to an end. And I thank all the attendees for joining us, and wish all the other participants in International Mediation Awareness Week good luck in raising the profile of mediation and its use throughout the world. Thank you so much from Garden Court Mediation.